Welcome, welcome, welcome. Let me get rid of these things so that we can get started. Hope everybody is doing great. Holistics, lawful, always. Welcome, welcome. Today, we are going to talk about some more law. We're going to talk about some solutions. Sabak, lawful, always. We're going to talk about some lawful solutions and how we can mitigate some of the issues that people commonly share with me. Let's see if we can bring up. I'll bring up a couple of documents so that we can speak lawfully. Yeah. We can make sure that we give reference to the things that we're talking about. Excuse me. I know I've not been on here frequently as of late. However, we've been covering a lot of ground in the background. So this year, we're going to get more serious about solutions and get out of the world of, as they would say in college, theoretical physics, right? We're going to get into actual practical physics of using what you learn and stop watching people and being entertained, right? So those of you out there with the tickets, those of you out there with situations that does not appear lawful, those of you out there encountering people who are telling you that they are the law, there is no one that's untouchable. Just remember that. Everybody have to answer to somebody. And that is not a threat. That is stating the facts. Those of you who are in class, you know what I'm talking about. Nobody is untouchable. So, at the end of the day, no matter what somebody wants to tell us a road, you see, when it comes to the law, everybody humble. Everybody get humble when you buck up on somebody we actually know what them talk about. Everybody get humble when them see say lawsuit is in motion. Everybody humble when them see say charges are being investigated to be laid. Everybody get humble when subpoena start drop. And that's one of the things I'm going to talk about today. Right? How do we ensure that we don't waste our time in court? What is a subpoena and who can we subpoena? What can we subpoena? Why would we use a subpoena? Excuse me. And a subpoena is a very powerful document. A subpoena is a very powerful document. Most people don't even consider it, even when they are in legal situations. The layman doesn't know how to institute, how to craft, or how to issue a subpoena under the court's authority. What you do is you go to court and you wish and a hope. That is one of your problems. You don't play a game until you are certain you have a chance to win. Wishing and hoping is not a chance. Wishing and hoping is a wish. It is something that is a fleeting thought. But when you practice, when you become familiar, when you learn how to swing a hammer, that is completely different from reading books, from listening to people. The experience is what matters. It is not learning through other people's eyes. It is the experience that you garner. That is really what counts. Raja, lawful, always. Greetings, Kem, lawful, always. Welcome everyone. And today we're going to talk about a few things. Because I always love the challenge, you know. You see, when people are out there giving information, I always used to wonder, why are they giving you teasers? Why don't they give you something that you can use? Everybody try sell something. Whether they must sell hope and dreams, or they must sell a product or a service or a consultation, or everybody try sell something. And it is that mentality that causes us to be in the problem in the first place. Because if you don't buy justice, oftentimes you don't get it. I don't mean bribes. What I mean is, if you don't pay for an attorney and you know nothing about law, then it's most likely you're going to lose. Damien, lawful, always, welcome. Welcome one and all. So this is why I have this page. You can at least learn little by little until you gain traction, and then you can take your time, put your foot in the water. You can take your time, step out. Then eventually you just jump in. You ever got to the beach yet? And the water cold. Yeah, say, yo, the beach water supposed to warm, but the water cold. So you have to take your time, you put in a foot, it go up to your knee, you tremble a little bit. Until one time you just have to say, yo, you have to just jump off in the water. Because if you don't jump into the water in some cases, it is harder to take your time and a dilly-dally until you reach somewhere. You just jump off. Because eventually, you want the water all over you, don't. So, you just jump off in the water. That is how the law is sometimes. Sometimes you have to just put everything else aside and say, listen, this is my focus right now. And this me I go tackle. And you take your time and you learn and you practice. Learn and you practice. Learning alone through other people's eyes is not going to give you the experience necessary. You have to go in a court. Well, you don't have to, but at your level, you have to. You hear a lot of people talk about constitutional rights. You hear attorneys using the term. But have you ever looked into a court case and check what the judges say? That is important, you know. It is not what people outside the courts are saying, because it is the judges who interpret the law. It is not the attorneys. It is not the clerks of court or the clerk. I don't know where this term comes from, clerk of court. The clerk of court. There is no such thing as a clerk of court. It is the clerk. Anyways, it is the judges who determine what the law is as it applies to your case. It is not the attorneys. So that is very important. So when you want to get advice, go and look up a court case, go on the Supreme Court website, go on the Appeals Court website, go and see what these judges are saying in the case. Some people will quickly say, me not understand what them are say. This too long for read. 20 page of the deliberation. If you don't start, how can you ever understand? If you don't start and try something, how can you ever get there? You will lose 100% of the chances that you don't take. So at least fling one stone in the water. You might lick one fish in the head. Oh gosh. Alright, let me take the joke out of this thing. So, I'm going to share a few things with you today. Alright? I'm going to share a few things with you guys. We're going to do a couple of things. We're going to go over the Bail Act, because I realize that there are many people who end up in situations that they don't realize what is going on. And unfortunately, even the judges sometimes, they know better and they are not doing better. It is up to you to bring up these things in order for you to prevail. All right? Exactly. Just like the ripples of the water, you see the effects of your actions. If you don't take no action, you can't get no effect. So, the first thing we're going to talk about is the Bail Act of 2023. And for those of you who are asking, or you are about to ask again, how do I get a hold of this document? Can you email it to me? No, I will not. Go to Google and you search the Bail Act Jamaica and you will find these documents. So all you have to do, search for the name and put Jamaica at the end. You should not be relying upon anyone to get access to resources that are available to everyone. Okay? So you go on everybody, if you're there on TikTok, you can't find it. There is no excuse. If your phone full up, go delete couple video and couple picture and download the Bail Act so you can read it. The Bail Act is only 46 pages. You won't even need to read that much. But I suggest it. If you don't know what is in these acts of parliament, how can you know how to defend yourself? How can you know how to hold people to the law? How can you bring it up in court if you don't know? That is the point of teaching you some of this, all right? So, that being said, let us take a look at the computer, all right? So this is, see if we can center this thing here so that we can read lawfully. See? And I'm going to explain to you once we are done here. I am going to explain why we go over the Bail Act. Okay? For right now, you just have to pay attention and stick with me. It is important that we go over this because anyone can face somebody giving you the option of bail or no bail. Okay? All right. So, to start things off, it says, an act to repeal and replace the Bail Act and to provide for connected matters, 15th day of November 2023. Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the Senate and House of Representatives of Jamaica, and by the authority of the same as follows. So you notice this was signed by the Governor General, all right? Sir P.L. Allen. It says, This act may be cited as the Bail Act 2023. You know what this means? I'm going to teach you something I would normally go deeper in signatory class, right? I'm going to teach you something today. It says that this act may be cited as the Bail Act 2023. That means that this is the official name for the document. If anyone references the Bail Act and does not reference it by its proper name, it is invalid. It is an invalid reference. It is now null and void. Okay? So, if you ever get a document that says according to the Bail Act, X, Y, and Z, it is invalid because that is not the name attributed to it according to law. Okay? So that is the first thing, just like how I break down a ticket on the page. It is the same thing in any body of law. Okay? If it has an official name, it has to be cited properly. All right. In this act, arrested includes the apprehended. And I will have questions and answers at the end. So make sure you write down your questions and answers or your contention or your challenge if you have one. Okay? It says arrested includes the apprehended. So when the police so I'm gonna stop reading the comments. Anyways, let us not slow things down. When the police apprehend you, right? Meaning they stop you from going about your business. You are currently detained or apprehended. Okay? So, according to the Bail Act, that is considered an arrest. It is right in front of you. Okay? So, when you get stopped for whatever reason, you are actually considered to be arrested under the Bail Act. Okay? If you don't realize this, you don't realize that you already have rights under the Bail Act. So here, the document is making sure it tells you, from the very start, arrested includes anyone who is apprehended. Whether they are questioning you, whether they are telling you to pull over, to ask for your license, to ask for your documents, that is considered an arrest. Okay? All right. Bail center means any facility declared by the minister pursuant to Section 20 to be the bail center for the purposes of this act. We never went into that several months ago. Child means an individual under the age of 18 years. Okay? Conviction. Here is an interesting one. See if we can zoom in and bring this over. Conviction includes a finding of guilt. A finding that a person is not guilty by reason of insanity. A conviction for an offense for which an order is made, placing the defendant on probation or discharging the defendant absolutely or conditionally. Now, this is an interesting word. And here it is telling you the criteria for the word. Right? Now, it is saying the conviction include somebody that is found, includes a finding of guilt. So if somebody is guilty of something, you have been determined to be guilty by a competent court. Excuse me. A finding that a person is not guilty is also a conviction. You see B? A finding that a person is not guilty by reason of insanity. That is also a conviction. A conviction is also a conviction for an offense for which an order is made placing the defendant on probation, or discharging the defendant absolutely or conditionally. So even if you are discharged, you are still considered convicted. It's a conviction. So it can be a positive conviction or a negative conviction. Deciding official means the court, judge, justice of the peace, or constable, as the case may require. I'm going to read that again because I hear people running around here talking about who can issue bail. Excuse me. Deciding official, meaning the official who is deciding if you can get bail or not, means the court, which is listed first, right? The court is where the police should bring you first. You should not be placed in lockup before you go before a judge or the court. That's why they are placed here first in the definition. But don't take my word for it. We're going to verify how this aligns with other laws that are older than this law. Okay? Deciding official means the court, a judge, a justice of the peace, or constable, as the case may require, who is the competent legal authority on the matter of the grant of bail. Some people might not realize how significant this is, But in any case where someone is deciding to give you bail or not, they need to be the competent authority, the competent legal authority on the matter of granting bail for that specific case. It cannot just be anybody. They have to have experience in the case that they are currently determining whether or not to grant you bail. Okay? Or any question related thereto pursuant to this act or any other law. So this is circumstantial. It does not mean that just because a JP has the power to issue bail, he can issue bail in any matter. That is not how it works. It says, as the case may be, and these are the different individuals who can issue bail. All right. And you see up here, so it says, based on the competent legal authority. What does B say? B say, in the case of a constable, because what? We know that constables are not legally competent in many cases. Right? The constable is the first one that's going to tell you, I am not someone who studies the law. So they are not going to be able to answer any legal questions you have about the law in many cases. Okay? So it says, in the case of a constable, shall not be the arresting officer or an officer involved in the investigation of the offense concerned. Let us read that in context again. The deciding official means the court, judge, justice of the peace, or constable, as the case may require, who, B, in the case of a constable, shall not be the arresting officer or an officer involved in the investigation of the offense concerned. You know how many bail applications and bail enforcement are invalid because of this very definition? There are so many cases where the arresting officer is the one they're writing up the bail application and telling you to sign. So many cases where other officers who are involved in the investigation of the offense concerned are the ones issuing bail. Even the superintendent, if he is there in the station offering you bail, and it is his direct command who instituted the arrest or the apprehension, he is not a qualified individual to be issuing bail. You know what that means? In many cases, nobody in the police station can issue bail as a constable. Nobody. Anyways, we're going to proceed. Defendant means an individual who is charged with or convicted of an offense. This is also very important. So the moment you get a ticket or the moment you get apprehended, you are considered to be a defendant according to the Bail Act. The moment you are charged with or convicted of an offense. Typically, the constable will say, listen, we are charging you with this offense that we witnessed. Or we're charging with this offense that we observed. So you are now considered a defendant, whether or not you are brought in front of a judge. B, defendant means an individual who is detained or arrested for an offense or for whose arrest a warrant endorsed for bail has been issued or who has not yet been charged with the offense. So whether or not you are charged, as long as the police detained you, as long as customs detain you, as long as any agent of government stop you from going about your business, you are considered a defendant as it concerns the Bail Act. So it's not only when you go to court, it's not only when you get a summons, it's not only when you have a court date, it's not only when you're in front of a judge that you are considered a defendant. You are a defendant once the police engages you and stop you from going about your business. So for those of you who are of the mindset that just comply with the police, just make them do them job, just do this and that, I agree with you, let them do their job. But here's the thing. You need to know your rights. You need to know what you can do in case they decide that you get locked up today. That's why we're going over these terms. So, it says a defendant means an individual who is detained or arrested or for whose arrest a warrant endorsed for bail has been issued or who has not yet been charged with the offense, but does not include an individual committed in default of payment of any sum of money or for want of sufficient distress to satisfy any sum of money or for failure to do so or abstain from doing anything required to be done or left undone. So what does this mean? This means that this does not include anything related to civil matters. Anything related to civil matters is excluded from this. Okay? Judge means judge of the parish court, a judge of the Supreme Court, or a judge of the Court of Appeals. Not even gonna get into why they don't list justice here. Anyways. Offense includes an alleged offense. When the constable say, we observed you committing this offense, that is called an alleged offense. The constable does not have the power to convict you on the side of the road. The constable is alleging. That is why you can go to court and contest your ticket or contest your arrest and contest all these matters because it is alleged. Surrender to custody means surrendering into custody at the time and place appointed in the prescribed record. Prescribed record means the record of a decision regarding bail made pursuant to Section 10. So those are the definitions. And as you can see, or you should see, how powerful it is to know what these terms mean and what is meant when you are offered bail. Who are you when they offer you bail? Okay? All right. Number 3. So we just went through paragraph 1, which talks about the... Paragraph 1 talks about the name of the act. Paragraph 2 talks about the definition. And now we are at paragraph 3. Paragraph 3 tells us who this act applies to. Now, this is a very rare occurrence. In most of the acts of parliament, you do not see an application of the act, who the act applies to. Okay? But today, this is a special act. It says this act applies in respect of bail to a defendant. And we just went over the definition of a defendant, right? You are a defendant once the police engages you, basically. All right. 2. The question of bail where the defendant is a child shall, unless otherwise provided in any other act, be determined by a children's court in accordance with this act. So, however, that in any case where bail is denied, any order made by the court for the child to be kept in custody shall be in accordance with the Child Care and Protection Act. For those of you with children, you should go out and go take a look at this act so you don't have your rights abrogated or abridged or set aside unlawfully. Those who do not assert a right, waive those rights. Okay? Subject to subsection 4, where a parent so this is talking about children, right? It's talking about children. Section 4. Subject to the provisions of this act, a defendant is entitled to be granted bail by a deciding official pursuant to a power to grant bail conferred on that deciding official under this act or any other law. Okay? 5. The question of bail to a defendant shall be decided in accordance with this act by a deciding official, A, within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense listed in Part 1 of the first schedule, in any case where such a defendant has not yet been charged because more time is needed to prefer charges. So here it has a reference to Part 1 of the first schedule. And as you know, these things are intentionally done. Instead of them putting here, so what is the list of offenses in this schedule? Just put them right here, so no? You're not running out of paper. Just put them right here, so. Them send you figure fishing. So let us find the first schedule. It says within 48 hours after the unreasonable grounds that the defendant has committed an offense listed in Part 1. So let's find Part 1 of the first schedule, right? So let's see if we can find the first schedule. So we have some forms. Let's see first schedule yet. Let's see if we can find it. Is it third schedule? Yeah. So let us see. I think I just see second schedule a while ago. Second schedule. So first schedule must be up here, so. Or pass it. Let me pass it. Hold on there. Let's find the first schedule. First schedule. Here we go. So these are the lists of things that bail can be offered for. 1. Unaliving. 2. Any offense under section 2, 3, or 4 of the Treason Felony Act. 3. Any offense under section 3 of the Malicious Injuries to Properties Act. Arson of a dwelling house. 4. Any offense under section 13 of the predial larceny and section 42A extortion of the Larceny Act. 5. Any of the following offenses under the Offenses Against Persons Act. So we have a list of things here under the Offenses Against Persons Act, right? Conspiracy, soliciting to commit unaliving, administering poison or wounding, destroying or damaging buildings, setting fire to ship, attempting to administer poison, or by other means attempting to commit unalive, pew and other pew to cause intent to wound or intent. What do you say? Child stealing, kidnapping, any of the following offenses under Dangerous Drugs Act. Any other offense under Section 4 of the Trafficking Persons, Child Care and Protection Act, any of the following offenses under the Sexual Offenses Act. So hold on, I'm not see nothing about traffic. Abduction of children, violation of persons, threatening fraud, abduction, unlawful detention with intent to have, perverting the court of justice. So, under the Law Reform Fraudulent Transactions Act, Criminal Justice Suppression of Criminal Organization Act, establishment of criminal organization, being part of or participating in facilitating serious offense by a criminal organization, taking retaliatory action, any offense under the 54 of the Unlawful Possession of Property Act, Firearms Prohibition Act, possession of prohibited weapons, stockpiling, trafficking in prohibited weapon, possession of prohibited weapon, manufacture, stealing, dealing in prohibited weapon, use and possession of firearm, possession of firearm. So this is the second schedule. What's this? It looks like them list this twice. So we see nothing here in the first schedule having to do with traffic and traffic stops. This is all talking about, and they list the different acts here, and they give the different contexts: prohibited weapon, prohibition and diversion, use and possession of firearm, blah, 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 right? Retaliatory measures, Law Reform Act, Fraudulent Transaction Act, identity, transmitting, distributing identity information, obtaining a benefit by menace. Lord of mercy. All right. So we've been through this entire schedule, right? Let us go back up here to 4. So we remain in context. So it was 5. It says, within 48 hours after the defendant is arrested or detained on reasonable grounds that the defendant has committed an offense listed in Part 1 of the first schedule, in any case where such defendant has not yet been charged because more time is needed to prefer charges. So, this has nothing to do with traffic. This has nothing to do with the police stopping you on the side of the road. Right? Let's go to B. Within 48 hours after the defendant is taken into custody, consequent on being charged with an offense, and after the defendant having been convicted of an offense other than an offense listed in Part 2 of the first schedule, in relation to which the defendant was out of custody on bail immediately prior to the conviction, applies for bail pending determination of an appeal made by the defendant against the conviction or against any sentence of imprisonment imposed in respect of such conviction. So has anyone seen anything related to traffic? Maybe I am missing something, because I read this a couple of times, right? And in order for someone to be given bail, it has to be something that is listed here in law, right? And if you notice, it is not a full stop here. So what does this? When you don't have a full stop, doesn't that mean that it is all contained in one, meaning that all of these requirements have to be met in some way, shape, or form? So if the issue is not met with A, you go on to B, right? And if B is not met, then you go on to C. But here, it is not saying one or the other, it is saying and. Means that this is an entire requirement. So if you don't match the description in the first schedule as someone who it applies to, your situation having applied to what is described in law, then how can you be offered bail? Now again, if them find something them not supposed to find, when them a dig you up and all them something, that's a different story. But if you're a regular individual, and let's say them say, well, you tell the police X, Y, and Z, and them decide, say, them not like that, and them are going to lock you up for the night. Then them a try offer you bail. That is unlawful. Section 5 gives the loan criteria. They have Section 5, 1A, B, and C. That criteria has to be met. And it goes back again here. So after the defendant having been convicted of an offense other than an offense listed, that would be an invalid bail application. 5.2. The deciding official for the purposes of subsection 1. So for the purposes of this section, A, in a case falling within subsection 1A, shall be a justice of the peace. 2, a constable at or above the rank of superintendent. So if you ever hear Mr. Dunn talking, he will commonly let you know that all, excuse me, all officers are also constables. And here it is reiterated again, a constable at or it has to be one of these things listed in part 1. In part 1. Right? A superintendent is unqualified to offer bail. This is why a judge must be consulted immediately. That 48-hour window that they are mentioning is only related to serious offenses that fall under other bodies of law, not traffic. B. In a case falling within subsection 1B, except as otherwise provided in subparagraph 2, shall be a constable, a justice of the peace, or a judge. In the case, let's talk about this. Except as otherwise provided in subparagraph 2. So except as provided in 2, right? Shall be a constable, justice of the peace, or a judge. And in the case of an offense listed in part 2 of the first schedule, shall be a judge. Right? So, again, this is in relation to those items listed in Schedule 1 or Schedule 2, which again, none of these things list any offense within the Road Traffic Act or the Road Traffic Regulations. Use that wisely. In a case falling within subsection 1C, shall be either the judge before whom the defendant was convicted or a judge of the Court of Appeals. Section 1C. The defendant having been convicted of an offense other than an offense listed in part 2 in relation to which the defendant was out of custody on bail. So this is somebody who was already offered bail for one of the things listed in Schedule 1. I know this is a bit confusing for those who can't really follow along, but it is basically saying the items that are listed for which bail can be applied is listed in this document. Then can't just get up and say, well, may I offer you bail because you're coming at the jail or somebody bring you to jail. That is not how it works. It has to be specific to a body of law that they have the authority to issue bail for. Where in any case falling within subsection 1A, more time than is specified under subsection 1A is required so that an identification parade can be held in relation to the defendant shall, instead of the time specified in subsection 1A, be brought before the judge within 120 hours after arrest or detention. So if it is a serious matter where someone was injured or unalived, a justice of the peace is not qualified, especially where there is an identification parade. It says you're supposed to be brought in front of a judge within 120 hours after the arrest or detention. B. An identification parade is required to be held in relation to a defendant but has not been held within the time specified in paragraph A. The matter shall no later than 48 hours after the expiration of that time be referred to the judge, who shall either specify such further time as shall be allowed for the holding of the identification parade, and upon the expiration of which the defendant shall be brought before the judge for the question of bail to be determined. Okay? So, I'm not going to harp on this very much, but you get the point here. You need to be qualified for bail to be offered bail in the first place. And in order to be qualified for bail, you have to meet the criteria for which bail is granted. If it is, I don't know how many of you were on the last live where I shared a templated document on the live, and I went over the document. If it is that you are not qualified for bail, you have the option of demanding that you be released on your own recognizance. What does that mean? To be released on your own recognizance means that there is no applicable situation where you can be lawfully held. And therefore, also, if you are not a danger to society and there is no lawful reason for them to hold you, right? It is not just the fact that they are offering you bail, right? The refusal of bail is a different story. You need an alternative. You need to have a remedy. In law, there is always a remedy. If you notice, in what we have read thus far, nothing in there states that the individual has the option of getting released on their own authority or being their own surety, right? One way they can release you is to say, well, we're going to keep your driver's license so you do not commit other offenses, right? That is where you can offer something to say, well, I am not going to flee. I am going to ensure that I, go to my court dates. I am an upstanding member of society and I have not harmed anyone. One of the main factors of being released on your own recognizance is there is no proof that you have harmed anyone or you have done anything serious. Right? So you can demand that you be released on your own recognizance. But you can go a step above that. For a long time, I've said to many of you, do not argue with police on the side of the road. A lot of things you won't understand because you come a class. So you can't really overstand the full 100. However, the public notices serve an important role. You can publish them in the paper or you can send them to the relevant authorities. So in the case of the last public notice that I posted on my page, that can simply be sent to the Commissioner of Police, the Supreme Court, and the police station. Well, you won't know the police station, because you are not apprehended yet. But if you send something like this to the Commissioner of Police before anything happens, because no founder wait until something happen, then you say, right, you know, say, I should do that. You know, say, I should buy the dash cam. You know, say, I should have this, I should have this, I should have this. You can't wait until things get serious and you say, boy, I'm sorry, I never do that, You know, say, I could have buy the dash cam with you, but the brother sell it for $5,000, or the brother sell it for $9,000. That $9,000 could have saved you 2 or 3 tickets. Could have saved you in a certain situations where you have your evidence and you can bring it to court if necessary. When you have a private declaration and you send it out to these government agencies, if and when you have to go to court, you can show that they were properly notified. Right? So when you demand that you be released on your own recognizance, it is not just something you are demanding on the spot. You already placed them on notice. Okay? So, what do you declare? You declare your right to be released on your own recognizance. And also, if you are apprehended for no crime, you demand to be released on your own recognizance. Right? That is what you let them know ahead of time. So, if you are apprehended, then it is already clear that you demand that you are released, because the only thing they can hold you for are crimes. This is why they list the different crimes in the different acts. If you don't state your rights and state that you have these rights and you are asserting these rights, then the problem comes in with legal notice. You see, in every act of parliament, right? They publish it in the Gazette. They post it on the website so you can download it. They make it publicly available. Most of you think that then just do that as a formality. Then just make it accessible to everyone to download it. That is not the case. Did you know that when something has been posted publicly, you individual can send a rejection notice to Parliament, to the Senate, to the Governor General. You can say, I don't accept this. I demand that the Supreme Court review this matter for constitutionality. You have the power to do that. But because you don't wait for be entertained, you don't wait for see who is winning and who is not, who is dancing and who is not. Tell them to come to class. If we keep on have individual wins, there are many people out there using the information and being successful and all that. Congratulations. But the ultimate thing here is, if we don't stop some of the unlawful activity, if we don't stop the oppression of legality purporting to be lawful, most of us are still going to suffer. Big up yourself. Thank you. Most of us are still going to suffer because we don't learn. We don't take it serious. We don't try to take our time and institute these things so that it becomes second nature. The information is always there. The information don't go anywhere. It is just you have to take the initiative and say, well, I'm going to take my time and read a 1 page a day, you know. Imagine we have probably 15 hours of waking time, right? Round about 15 hours where we can walk about and do whatever we want. And how many of us will take 10 minutes and read a page? I mean, it shouldn't take that long still. Imagine you have 15 to 18 hours, right? Where you can take 1 page, you can take 10 minutes out of your day and read 1 page a day. And you don't do it. But when you get a ticket, you're a ball. When you get a ticket, you run up and down. When you get into all these scenarios, when you buy something online, it reach a customs, them slap you again with taxes, sometimes 100% tax. And you say, boy, yo, the system oppressive, the system this, the system that. It is not the system. It is you. One cocoa full basket. You take your time and you walk. Most of the problems that you have, or any kind of problem that you have, there is a solution out there. Nothing is new under the sun. I guarantee you, nothing is new under the sun. Any problem that you're having, somebody fix it already. You just don't know about the fix. Any problem you have right now, there is somebody who gone through it before and they know the solution. And it's because nobody not really care, nobody not really complain. Why give the solution? What is the schedule for lives? I don't have a schedule because what happens is when I put a schedule, we have government agents that come on the lives and they start reporting it. Even for no reason at all. And then the live gets shut down after a while. So I don't put up a schedule. See? So you can follow me and set the notifications and you'll see when I'm live. But I cannot go on a schedule because this information, apparently not everyone wants people to learn. Okay? So, that being said, when we have situations where we are being targeted as individuals, random stuff, let me see your documents, even though the commissioner tell themselves to stop the practice, even though it is unlawful, even though the Supreme Court routinely said we do not need to carry a pass around, we don't need to be showing people that we have documents. That is not a lawful action to be carrying out. Okay? Now, even with all of that, even though the courts have said it, even though the commissioner have said it, it appears that each parish have a mind of their own. Each police station in the parishes, they have a mind and authority of their own. it don't seem like say they answer to any authority unless there is public outcry, or unless they get investigated and in some cases nothing still not happen, or alternatively you learn how to sue them, because most people out there being oppressed legally, they don't have the resources to be paying for attorneys left, right, and center. And the attorneys are not going to work for free. So if you don't learn how to do it for yourself, what do you think is going to happen? Because right now it is what? It is profitable to issue 100,000 tickets a day. It is very profitable. So why would they stop? Why would the constable stop issuing tickets if it is incentivized and it is profitable for the government? Just because someone is doing something and they don't get caught, that does not mean that it is lawful. Just because something is accepted generally, that does not mean it is lawful. Until it is challenged. Until these things are challenged properly, we will continue to suffer. People suffer because of lack of knowledge. You see? So you have to learn. You have to learn if you want better for you and your future generations. And the other thing I want to point out is that the law, right? The law is effective, you know. Just because it is not effective for you, that does not mean it does not work. Let me say that again. Just because the law is not effective for you, that does not mean that the law does not work. Can I speak on traveling versus driving? Yes, I can. Lawfully. So, we have something called driving, something called traveling. By the way, this is like talking about something in the tree when you have things at the root that are relevant. But I'll answer the question directly. Traveling is something that is not regulated. It is something ancient and something that is commonplace to everyone. It encompasses all sorts of movement. Once you get up and you can move, that is a form of traveling. And that is a common right for every single individual. Whether or not you're a child or an adult, you have the right to travel or the right to free movement. Driving is a term attributed to people who are conducting business using a mode of travel. So what is the difference between someone, for example, driving a taxi, driving a bus, or someone bringing materials for hire or for pay? What is the difference between that and someone who simply is just traveling from one place to the next, from point A to point B? There is a legal difference. What do I mean by that? If you look at the Road Traffic Act and the Road Traffic Regulations, these two terms are omitted, right? Driving and traveling, or driver and traveler, are omitted from the definitions. There is nowhere in Jamaican law you will find the term driver or traveler in the definitions. So what that means is, if you don't define something, right? Anyone can use whatever definition they want. So, if we look up the definition of driver in certain legal dictionaries, like the Black's Law Dictionary 4th edition, matter of fact, let us pull it up. So we can speak lawfully. So Black's Law 4th, and let us find driver. Drive. Doubt. Drift. Drinking. Drive. Driver. All right. So let us take a look at the definition of driver. All right. Let's see if we can center it. All right. Driver. Let's see if I can bring this up. I think it's zooming in too much. All right, here we go. This is called the Black's Law Dictionary 4th edition, 1968. It says driver, one employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. A person actually doing driving, whether employed by owner to drive or driving his own vehicle. Right? So a person employed by owner to drive or driving his own vehicle. Right? And as you can see, this is one definition. It doesn't say definition 1 and definition 2. This is a single definition. So one employed in doing these things. Right? So if this is the definition of driver according to a legal dictionary, and where do legal dictionaries get their terms from? Legal dictionaries get their terms from the courts. So they often list the court cases that define what these things are. Right? So this is not just, scholars coming up with terms. This is not just people making things up. These dictionaries are often used in the courts to clarify what things mean and the context of how to apply things. So a driver has to be someone who is doing something for profit or gain. So when the constable stop you and say, driver, you know how fast you're going? That is an incorrect term to use. You are not a driver unless you are actually employed in doing the activity that is being referred to. Okay? Someone traveling is a completely different thing. Right? Why the police can stop you for driving or being a driver? It is simple. If you are a driver, you are employed to do something, whether you are carrying things for somebody or you are carrying people for a profit, etc., etc. But the reason the police can stop you is because you have a reasonable expectation of care that you need to carry out as it relates to someone else's property or someone else's life. Okay? So, that being the case, this activity is often regulated, meaning you need a license to do these things. And if you need a license to do these things, that means that it is something that has to be looked into, something that has to be ensured that you are following the policies and the procedures of that license. Right? So that is why you have these two terms. And that is why oftentimes you will not find it in regulations, because they don't want people to have this definition in front of them. You have to go search for it yourself. So if you don't know what driver means, you are subject to the terms and conditions of this word once it is being used. So when you go into court and you just say, how fast were you driving? You think in a layman's language and think, say, the judge just talk about how fast your car was going. No. The judge is also specifically talking about you are employed in doing something, and thereby you are now attributed the term driver. So if you don't object to that term, then you agree that you were conducting a regulated activity. Because remember, you cannot face consequences of something that you are not a part of. As a traveler, the driver's license does not apply to you. Let me say that again. As a traveler, the driver's license does not apply to you. Let me explain why. If you are not in an activity that is regulated, for example, you are not currently carrying somebody for hire, or if you are not currently carrying somebody's goods for them for payment, that means that you are not doing something that requires a license. So if you are not doing something that requires a license, that means that the license is not active. That means that the license is dormant. It has not become operational for what you are doing. Hope that makes sense. But also, to bring things into context, right? If we go to the Road Traffic Act, let us bring this full circle. We go to the Road Traffic Act. I think it is section 20. Application for driver's license. Section 21, right? This is the Road Traffic Act of 2018. Let me take off this off of the screen so that we can get some more screen real estate. All right, so here we have, so we'll get to questions. Here we have Section 21 of the Road Traffic Act of 2018. And if you look to the left of the document, it says application for driver's license and learner's permit, right? However, Section 21(1) states, every person who is desirous of obtaining a learner's permit or a driver's license. Every person who is desirous, meaning you desire to get a driver's license or a permit. It never says every person is required by law to obtain a driver's license or a permit. It does not state that. It is saying if you desire to get one, then these are the criteria and the restrictions as it relates to this application. Right? So this here is also speaking volumes, because it is not a requirement under law. It is an option. You have an option not to get it, and you also have an option to get it. I am not telling you not to get it. I am not telling you not to get it. However, there are other ways of using the driver's license other than just giving it to the constable. Okay, there are other ways of restricting how this license applies to you than to just be out here handing out your personal information and your private information, incriminating yourself. There are other ways to operate in society. Okay, we're not going to get into that here. That is for private class. I can't divulge that information. That's a little bit over the head of TikTok. So, as you can see here, a driver requires regulation because you are carrying property or people which are considered essential parts of society, and you can also put these people or property in danger. And if you put people in danger, that activity must be regulated so that you ensure the safe passage or the safe carriage of people or property. That is the purpose of the license, to ensure that you abide by the rules of law according to the road. Okay? And this actually makes sense when you talk about doing things for hire or doing things for a profit. But when you talk about a private individual, this can never go into effect because, especially if you are traveling alone, it does not make sense for the police to stop you and ask you about if you have documents. That is a violation of your privacy. That is stopping your free movement. That is interfering with your private life. All sorts of different things. Zin? So, there you have it. I'm going to open up the floor for questions, comments, emotional outbursts. So you can select a box if you want to come up and share something, ask a question, or just say thank you. Zin? So it is important to learn these terms. It is important to learn the law so that you can properly and effectively defend yourself and also prosecute in cases where there is unlawful activity. No, I cannot cover malicious prosecution here. That is something that has to be discussed in private. So if you're a part of signatory class, then maybe we can talk about something like that.
Yes, blessed, my general. I not say a name for refer to you by, but God know this information that you're really putting out there.
Yeah.
Not everybody is going to welcome it, but I must say, I must thank you because I scroll, and I see it and I could pass. I
Yeah.
see the bail act right in front of me, and I say, I mean, a man, me run into the law a lot of times. And it's just by you basically putting this out there, I realized that there were a lot of unlawful means by which I was implicated. However, you know, them say you have to go through and experience certain things so that you now can be able to assist other persons.
Right.
And what we really want is like the context of information that you're referring to. Would I really want to get my hands on it so I can, you know, read up myself, get myself acquainted with the law a little bit more. The reason being, I am currently, to God be the glory, I am currently in the field of law working, and I aspire to really make the move further, and I believe that basically getting on this platform, seeing someone really advocating, giving people information like this, me support it. You understand? So it is very I must thank you first and foremost for take the time out for even do this. And that's why may I ask you and so me know the reason being. So me I go do the necessary so when you're on, me
Yeah.
really check in.
Yeah, man.
See? And you have to continue do it. You see me? And as how the law may permit you. Just continue do it. I really appreciate it. I really do.
Yeah, man. You know, say sometime at the time, you know,
Yeah.
got other things that go on and all of that, but I want to address your question of, you know, how you get some of this information. Are you talking about like the acts of parliament and so forth?
That and the book, the black book, the law, the black book,
Okay, Black's
the
Law
law.
Dictionary.
Where you say?
Black's Law Dictionary.
Black's Law Dictionary. Me keep on need for keep me, cause I know me not get to go up on Google. Black's Law Dictionary. So that is it is accessible on the internet.
I'm gonna show you right now.
Okay.
So any act where you want to look up, you
Get
can
my
go
pen.
to Google and type in, for example, Road Traffic Act Jamaica. Right?
Yeah.
You can type in Bail Act Jamaica. Right?
Yeah, man.
Any law where you look for, you can just type it in and type Jamaica at the end, and it will come up on Google. Right? So the Black's Law Dictionary now, right?
Yeah.
You can type in Black's Law Dictionary, 4th edition, PDF.
Alright, so Black's Law Dictionary. So it's spelled regular like black, like color black, right? Black's
Yeah,
Law.
man.
Alright, Black Law Dictionary.
4th
Fourth
edition,
edition.
PDF.
Aye.
And once you type that in, there is a bunch of websites that will have it for free.
Yeah.
Right? You don't have to pay for that. I mean, it is good to have the book, you know, but sometimes, especially this edition, might cost you a little bit to get it.
Okay.
You know? But once you have this, you can look up the legal terminologies and see what the words mean in law rather than use your layman's.
Yeah, frivolous way of just get terminologies.
Right. Now, may I go address something where you never really bring up, but we addressed this before. You have the Jamaica Supreme Court website, right?
Yeah.
Now, for those of you, the other people them out there who are talking about don't use Black's Law Dictionary, American something that and all of that. If you type in Black's Law Dictionary in the search box on the Supreme Court website,
Yeah.
right, you can see that the court itself refers to the Black's Law Dictionary.
Okay. Yes, indeed.
Whole heap of cases, right? You have different dictionary everybody using, but you can see where the court has accepted the definitions from these dictionaries. So
Right.
it is not something where you have to shy away from it just because it is mostly used in a specific jurisdiction.
Yeah.
You see me? As something where if it is to your benefit and it is not defined in Jamaica law, you can use it as your authority.
Yeah, it's valid.
Right. So, and you can go also on the appeals court website and do the same thing.
Okay.
Yeah, man. So that is definitely a good starting point where you know what you're talking about. You don't have to rely upon, what other people are using or what other people are saying. And if you have that, you can have that, if you have a tablet, you can bring a tablet, go to court, and you can ask that the court allow you to use a tablet for notes. Right?
Yeah.
And that can also be something you can have in court to reference while you're doing a case or whatever the case may be.
All right. So one quick question.
Yeah.
If all right, if someone was held in jail for approximately 6 days, how lawful is that without any proof of criminal activity or them being charged per se for any particular act within the Jamaican society? Is that lawful?
Well, I cannot give legal advice, but
Okay, I
in
understand.
my opinion, it depends on the context.
Inform me, yeah.
Yeah, it depends on the context, number one. Number
Mm-hmm.
two, it also depends on what rights you asserted. And number three, it depends on, again, the situation largely, because if, for example, I'll give you an example of, a justifiable reason in some cases. Let's say somebody say, people stole something from them, and
Yes.
they must say, all right, we need to find something related to that incident, and them do investigation. If the police, if the constables themselves can't complete an investigation, and them need other resources, right, and other people have to come in, them have to do whatever the case is, it may be justifiable. That don't mean say it's lawful to you, but the situation may be justifiable for them to extend whatever they are doing.
Okay.
But as it relates to you, you have to focus on your rights and what you decide to do. If you feel something is unlawful, you simply have to sue, right? You have to get your charges dismissed first, and then you can decide to sue. There is no other
Okay.
option when it comes to the law or comes to the state.
Okay. All right. All right. What I understand with law, it has a lot of complexity because as we know, situation has intricacies, and people tend to want to maneuver themselves through those intricacies, and for that reason the law basically subdivide or put subheadings and so forth, so that to keep people within a certain frame. I know that law don't come direct, meaning say anything in a law where you want to understand, you have to understand by pulling apart the intricacies, see the reason for it and why it is applicable. Just as how you said to me a while ago, say within a certain situation, if you breach, for example, if the police show up at your place of residence and the police say, all right, I was called here to this location, and you basically don't, it's like you basically, what do you call it, pervert the course of law, or them forward because they get a call to this area. Them knock your door and them say, all right, we're here because we got a call here. And then you lock back your door and you just say, yo, you're not letting no police, bond the police. And you start to say certain little tough, where put yourself in incrimination. So that would have caused the police to have the right to execute the law upon you. Right?
Well, it's circumstantial still, regardless of whether them get a call or not, them still have to follow the law, and them have procedures where them know so them supposed to follow. This is not a matter of them come out there and they don't really know what them are do. That is not the case.
Yes.
For those people out there who are wondering, the police actually go to college. They have to go through a whole bookwork course, several courses before them do physical training and before them can come on road. So
Okay.
I know something where then just they in a field, run up and down and big up themselves and then them come a road. And so it go. Them have to actually go through bookwork and material. So this is not a matter of guessing. Them have to learn.
Also, basically, the police would have basically go through like the basic course of law per se to
Right,
be able to administer the law.
right,
So they know exactly what are the breaches or the infringements and so forth.
right.
So once you are able to indicate to them that you have thorough knowledge of what
No.
the
I'm gonna stop it. So. We don't inform the officers of anything. You don't try to educate the officers on the side of the road or at your yard. None of that. No.
yes.
That is not your job. Your job is to protect your rights and enforce your rights. That's it. The thing is now, let's look at the scenario where you talk about. The police come at your house, them say them got a call, so they are doing an investigation. You have the right to say, I'm not going to participate in your investigation unless you have a warrant. I am exercising my right to ask you to leave my premises. Unless there is some kind of criminal activity you need to investigate, I am not going to be a part of it. But if you lock your door and you tell them go SOM or whatever, right?
Mm-hmm.
That's a different story,
Okay.
right?
Okay.
Asserting your rights don't mean you have to be disrespectful. Yeah, you might be annoyed or whatever, but you know, you do it a little bit professional, but again, you need the little knowledge to be able to do that, right? A lot of people disrespect police unintentionally, right?
Oh.
So it better if either you tell them, say, hey, I don't wish to speak to the police. If you have a warrant, please produce it, you know. But I am not going to participate unless I am required by law. And you leave it at that. If them say them are kick off your door, then you have to decide what makes sense to you, right? Because whatever the police decide, they are going to do it regardless of how you feel. So you just have to make that decision if it makes sense to you. But I don't advocate anyone out there tell the police, say, yo, this and that and a disrespect and a, no, do not do that. That don't make no sense. And it might get you in the legal machinery unnecessarily.
Yes. All right. One more question.
Yeah.
Um, persons who studying like all right, persons who want to practice law, right? What
Mhm.
advice you would give to them right now in terms of um or what information you would um provide them to say this is the way, all right, that direction is a good direction to follow in, and because you know there are different type of law and so forth. So which one of them you think is more beneficial, have more benefit and is more profitable per se?
I can't give any advice, but you can venture into any subject matter of law, but you can't really go into it for the money, in my opinion. If
Oh.
I was going to study to assist people as a lawyer
Mm-hmm.
or as an attorney taking clients, I would, look at what interests me because it don't matter what you pick. There are people out there with that subject matter problem.
Okay.
It don't really matter because people are gonna just end up in a situation and they want somebody to help them right now. That is how most attorneys get their jobs.
Yeah, that well, that answer they work, the answer they work with me. So that's pretty much what I really bring on this platform. But as I said, I'm very grateful for the information that you're rolling out. Me go there. Me go click the thing. Cause me new to TikTok, like last year November me start. And me
Okay.
realize this platform is very innovative. It you don't have to follow the crowd. You don't have to follow the what is trending. You
Right.
just you just have to be you and gather the rightful information. The greatest part me see of this TikTok thing, just like how you're here streaming, I found out
Yeah.
that I was able to record stuff when I do
Yeah.
and so forth. So it is really good, and really thank you for being an advocate and being a person who is really informing people so that they can help themselves with the law. Cause not much people do it in Jamaica. Me, if it's a Jamaica, is just relax, lads. And when the police decide say, "Man, take it up," I use it
Right.
to apprehend you. That's when it becomes active. Other than that, it's just
Well, it's just like people who don't have a car, right? When you do get a car, you start see your car all over the place, right? So,
Yeah, everyone at the box of them will pass. They say, "I hear a vehicle that."
right. The same thing in a law. When you take up a subject matter or you start looking into things, you start realize that, but wait, so much people have this issue, or so much people that do this. So it is just out of sight, out of mind.
That
Um,
is true.
but regardless of the route that people take, whether they want to do it professionally or they want to do it by themselves, it doesn't matter which one you choose, it is equally difficult. To go to law school, it's taking you at least 4 years of study, minimum. And if you want to go further, you're going to have to practice for longer. So none of it is an easy route. And if you're studying by yourself, you don't have the direction of a mentor in many cases to guide you on what to study and, how to effectively use your skills, especially if you're not in the court often. That is also a deterrent if you don't have a foundation or a body of people who you can exchange and learn from. So it is equally difficult.
Yeah. Tell me something. You have to do it in 4 years. You can't cut it down. Like, it can be done in like 3 years.
Well, you'll have to check with the universities that are offering that, but I don't think there's a 2 year program that you can really effectively be a full-time attorney with
Okay.
that knowledge.
Okay. All right, sir. Thank you for your time and
Yeah, man.
continue doing the good work.
Yeah, man. Same way. Big up yourself and thank you for coming up. And yeah, man. All the best. You can follow and you can know when I'm online, but
Yeah, man,
we
me
have a
follow a
schedule.
long time, man. Me follow. As me say, them content, I more turn, more go on for my up here. When time me go in, them something I would mind. You understand? I can't able
Right.
to update myself while me in the procedure of looking to actually be in the field practicing and so forth. So the more information we can collect, the better for me.
Right. Well, specialized knowledge. Correct.
Yeah, yeah, respect.
Yeah, man. Big up yourself.
All right.
Always.
Yeah, man, respect all the time.
Yeah, man. So I have I have room for one more question. If anybody else want to come up and join the panel. Like our previous guest is not feeling well. So, but either way, when we talk about things like Jamaican law, we have to realize that it is no different from laws in other jurisdictions. It is largely the same. The only difference is that most of the time we have legal processes being followed that have nothing to do with law. Or if it have anything to do with law, it is, I guess I can say, manipulated. There are almost no agency in Jamaica is following the law as it is laid out. And, I am not blaming anyone, but that creates not only a disparity, but it creates an opportunity for those who actually know the law, right? And reading the law is one thing, but practicing and knowing the law, knowing the intricacies, knowing how to defend yourself and object to things that you don't agree with lawfully is a completely different thing. What is the difference between the Constitution and the law? That is a big question. However, the law I say this is a big question because it requires an extended explanation, and it requires us to look at precedents and also what is considered law outside of what is commonly accepted as the law. An act of parliament is not necessarily the law. The reason I say that is because there are many things that are considered the rule of law, right? It is something within society that creates barriers and boundaries and limitations on what we do. However, that doesn't necessarily mean that it is law, because, for example, NIDS was being pushed and forced into power, into being law. And the Supreme Court says, no, it is not constitutional to be forced to use your personal data as something mandatory, right? Identifying people as a mandatory mechanism of society. So therefore, if, for example, an act of parliament is challenged and it is successfully defeated, it is no longer law. So what that was a rule of law, something that is being used that is not necessarily permanent. The Constitution, on the other hand, is what is called true law or organic law. And that law is something that does not change by a challenge per se. It is often added to offer more protections and offer possibly more boundaries. And often those boundaries are mostly for the government. And you can't necessarily challenge the Constitution, right? The Constitution is there as a protective mechanism for the people and setting limits on the government. An act of parliament is not necessarily law because it can be struck down and it can be made null and void and therefore no longer in effect, right? And also in the Constitution, it specifically states to you that Parliament shall pass no laws. But we can't get into all of that. There is also court precedents that shows that Parliament cannot make laws, but it is applied in society as laws because much of society, even those enforcing the law, is treating it as such without challenge. So, when we talk about the law, we talk about bail. When we talk about the Road Traffic Act and regulations, when we talk about license, those things require you to know what you are talking about. You need evidence of what you are asserting. If you don't have the evidence and you just come with your theories, what you think, it is completely different from me saying, well, here the legal definition states that a driver is someone engaged in for hire activities, someone being paid by some kind of employment, right? Here we have the definition within the Road Traffic Act that states that it is someone who is desiring of getting a driver's license, may apply for one. That means what? It is discretionary. It is something that someone chooses to do. It is not a mandatory aspect of society, right? And we have other aspects and different things that, go into all of these details. But with even those two basic things, you are not a driver, right? Unless you are conducting for hire activities. And here's another tidbit. When you have, for example, a constable giving you a ticket for, let's say you are carrying cement in your car, and they say, well, you need a different license for this. Your license does not allow you to do this, right? And you go to challenge it in court. When you go to court, there is one question you can ask. You can ask, what license activity am I being charged for? Right? Because the license is for licensed activity. It is not just a license just because. It is a license with conditions. And those conditions are the licensed activity terms and conditions. So the Road Traffic Act and regulations are for the license. So now, if you say, I cannot carry my own things, prove to me that I was conducting a regulated activity as it relates to the terms and conditions of this license. All right. So oftentimes you will see comments on a ticket saying, operating contrary to driver's license. That is not an offense. That is not a crime. That is nothing having to do with the Road Traffic Act or regulations or Constabulary Force Act or any of that. It doesn't make any sense. Operating in contravention of, eating while driving, distracted driving, has tint that is this much dark. Those are anyways. So when you comprehend the different aspects of these regulations and these acts of parliament, see, it gives you a different perspective to argue on. When I say argue, I don't mean blah, blah, blah back and forth. I mean presenting your case to the court. That is called an argument, right? If you don't present your case to the court and you just go and pay because it is convenient, that is no different from a conviction. Okay? So until more people challenge these things, it will continue. Failure to obey road sign. Yeah, they're gonna come up with all kind of comments that has nothing to do with law, because in law you have to be very specific. If you are going to charge someone, let me give you one more tip. If a constable is going to charge someone, did you know the constable has to sign under penalty of perjury and provide information and evidence related to the charge? You didn't know that. But every criminal charge that is laid, including those that you get in a ticket, in the form of a ticket, the constable has the burden of proof to showing that you committed a crime. And if the constable cannot prove that, the court must dismiss the matter. And that is what gives rise to constitutional claims like manifest. Rano, grand evening. Rano. Right, accidentally come up. All right. Got running already. Remote tours. Grand evening.
Lawful, lawful.
Lawful. Always. What
So,
up?
me, so, so me have a quick question. So, so for instance, you get a ticket for running a red light, right? And you
Mhm.
go court and you pay for the ticket, and then you get an next ticket for run the red light. Would that classify as double jeopardy?
Once you pay the tickets, you have no option. You have to go through the courts before you talk about double jeopardy.
The second time,
So, hold on, you pay the ticket,
yes, and you get a separate ticket, but at the
but all
same
right,
red light charge.
the first time you get the ticket, did you go to court and pay it?
Yes,
So you were convicted.
yes,
Okay. Now, did you get a copy of that receipt where they say you had to pay?
yes.
And that is from the court?
Yeah, from the court. After you pay, you get a receipt.
Yeah, then you can argue, you can go back to court and bring up that argument of double jeopardy.
Okay. Just to clarify upon that little more, you know?
Yeah, man.
Because me there try understand if a criminal matter only or traffic are the same.
Traffic is criminal.
Yeah, for real. Me
All
know,
traffic matters
but
are criminal.
yeah, definitely. Respect man and continue with the good work, man. I
Yeah,
don't know,
man.
lawful always.
Yeah, man. Big up yourself.
Yeah, man.
Kem, what's up?
Grand evening, LB.
Great evening. Great
So,
evening.
great evening. So, my question is, can a police officer, constable, or superintendent engage in civil matters?
Absolutely not.
And you would classify traffic tickets a civil matter, right?
Well, yes, because unless the ticket itself outlines a crime, then it is not a crime.
But can a crime be paid? Can be resolved in a civil court? Monetary
No,
fees can be.
no. But at the same time, we know that it happens, right? You get a ticket, and the ticket is considered criminal. The reason it's considered criminal is because you can go to jail, right? It has penal penalties. Like if you go to court and the judge find you guilty and you can't pay right away, you know that they will send you to jail, right? So now, if it is a matter of pay or go to jail, then that is a civil matter. That is what you call a conflated civil matter. They are combining criminal and civil within the same jurisdiction, within the same cause of action, which is also an invalid application of law.
So you having a tint and they give you a ticket for it and you decide that that's not lawfully, that's not lawful, and they send you to jail. Where is the crime in that? Having a tint is a crime?
No, it is not a crime, but it is what you do after the arrest.
Okay. All right, just playing the devil's advocate here.
Right. We all know the police
LB,
can do whatever they want. Right? The police is
for instance, you can't pay the fine and you go jail. You'd appeal that And conviction after.
Well, first things first, you need to come to class. These things, these questions that we're asking, a yes or no answer is not going to suffice, right? These are deeper questions. So we don't really talk about the intricacies of a case here on TikTok, right?
All right, lawful.
Right. So we don't want to confuse people because this is not a 10-minute or a 1 hour conversation. This can go into 2-3 hour conversations regarding, the details of what happened, the details of, what you should be doing from the start, what you can do in situations, what you can assert, all the different circumstances surrounding whatever it is, is not something we can discuss here on TikTok. It definitely have to be in signatory class for something like that.
All right, LB. So me I go come to class to learn the rest.
We're for their class, man.
Sounds like a plan.
Get my bag packed and come to class.
So how we go about becoming a signatory?
Go and play devil's advocate. So for those who are wondering, what are these people talking about? This signatory thing. You can go to, or you need to go to, in case you want to be a signatory and a student. You go to voiceofjamaica.com. Matter of fact, we already have a tab over here. This is the website, voiceofjamaica.com. And you have a signatories link in the menu right here. Right? You click on signatories. You fill out the form that is right here. If you want to know what exactly a signatory is, it is right here. It explains what we mean by a signatory and activating your rights as it relates to the Constitution and other treaties. So there's a link right here that gives you more information on what public rights activation mean. Once you are satisfied, you can come down here and fill out the form and wait for an email that you'll receive typically within a day. Once you become a signatory, then you will have access to log into this website and access things such as class. You hear I talk about class many times. If you go to class, you have the option here of learning different topics as it relates to the law, right? I have several different classes here. And for those who are wondering, there is no fee. There is no charge to get access to this information. You simply have to be a signatory. And once you're a signatory, you can come in here, you can access the classes, you can download documents. Under downloads, you have templates, you have documents, you have files. For those who are not signatories, there is a free docs option here. So you can click on free docs, and you don't need a signatory login to have access to these document files. These are templates and documents that you might find useful, right? So if you don't want to be a signatory, that's fine. You can also go through here and get access to some documents, but signatories have a larger library of documents that they can use. But for those of you who are wondering what kind of documents are in here, here are just a few. The public notices that you might find on my page are all, well, most of them are here, right? You have a religious exemption from vaccination template here. So if you have children and you don't want them to have the vaccine and all them something there, this is something that you can consider and review. You have a declaration of religion, genetic sovereignty, all kind of different things here that you can have access to, right? And you don't have to be a signatory for that free files page. And that's under downloads. And you go to free files, right? So those are just some of the things that you would have access to if you're a signatory. So that is all the time that we have today. I'm not sure when I'll be live again, but possibly before the weekend, I might find some more time to come live and share some more intricate details about traffic and the law. So big up on yourself.
Big up yourself, LB. Lawful always.
Always.
Lawful, man. Lawful. Don't know.